Today I'm going to tell you about 498A IPC. The Kerala High Court has acquitted a man and his family who were convicted under Section 498 IPC for cruelty against a deceased woman on the finding that the parties were living together as husband and wife based on a marriage agreement and their marriage was not solemnized. In the case on hand, since the marriage between the first revision petitioner and deceased Chandrika was not solemnized, and they started living together on the basis of a marriage agreement, which has no legal sanctity in the eye of law. They have to treat it as person in live-in relation, and they were not husband and wife. In order to attract an offence punishable under Section 498 of IPC, so the trial court as well as the appellate court went through wrong in finding the revision petitioners guilty under Section 498 of IPC and sentencing them for that offence. The deceased and first revision petitioner allowed, and they were living together as husband and wife based on a marriage agreement. Due to alleged ill treatment from the man's family, the deceased attempted suicide by self-immolation using kerosene and succumbed to her burn injuries. The trial court convicted the man and the family under Section 498A 306 IPC, and the conviction was upheld by the appellate court. The revision petitioners thus approached the High Court. The court, on examining the validity of the conviction, found that no evidence was brought on record to show that the marriage between the first revision petitioner and deceased were solemnized under any form of marriage, either religious or customary. The court found that they were living together as husband and wife based on a marriage agreement which has no legal sanctity. The court found that even if the marriage agreement was registered, it cannot be replaced for a legal valid marriage. Thus, the court found that they were living together as husband and wife without a valid marriage document. The court relied upon Rima Agarwal versus Anupam and others to state that the expression husband under Section 498A IPC would only cover a person who enters into a marital relationship. It also relied upon Shiv Charan Lal Verma and another versus State of Madhya Pradesh to state there must be a valid marital relationship between the accused and the victim for attracting an offence under Section 498A IPC. The court found that the dying declaration of the deceased stated that the first revision petitioner has a loving husband, and it was the family members who ill-treated her. The court also noted that there were no specific allegations made against the family except general allegation of mistreatment. It also found that the conviction under Section 306 IPC for avertment of suicide was not sustainable because there was nothing to show that the first and fourth revision petitioner. The court found that the prosecution was unsuccessful in proving the offences of cruelty or avertment to suicide against the revision petitioners beyond reasonable doubt. Thus, the court allowed the criminal revision petition and set aside the conviction of first and fourth revision petitioner and the order their release from the prison. So, the thing is, in case of 498 IPC, a person cannot file a case for or to the person who is not in a marital relationship. In this case or under this section, both victim and accused should be in a marital relationship. Otherwise, there will be no validity of this section.